Welcome to the Supreme Court Podcast.
All opinions expressed in this podcast do not reflect the views of the Supreme Court. For clarity, the text of the decision prevails.
In 2006, University of the Philippines Diliman student activist Sherlyn Cadapan and Karen Empeño were abducted by armed men in San Miguel, Hagonoy, Bulacan. A year after, former activist Jonas Burgos was abducted in a mall in Quezon City. Jonas is the son of the late veteran journalist and Ang Pahayagang Malaya, now Malaya Business Insight, founder Jose Burgos Jr. All remain missing to this day. These widely reported incidents are but a few of the numerous cases of enforced disappearances. On July 16 to 17, 2007, the Supreme Court, through the leadership of then Chief Justice Reynato Espuno, held the National Consultative Summit on Extrajudicial Killings and Enforced Disappearances, searching for solutions. The summit aimed to find answers on how to address these atrocities and violations of human rights. Before the summit, cases of extrajudicial killings and disappearances had been rising since 2001 on a scale reminiscent of martial law and had become a pressing concern both here in the Philippines and around the world. The summit gave rise to the crafting of AM number 07-9-12-SC, or the Rules on the Writ of Amparo, and eventually AM number 08-1-16-SC, or the Rules on the Writ of Habeas Data, two of the extraordinary writs. In the first of this two-part episode, we'll focus on the rule on the Writ of Amparo. What is the Writ of Amparo, and why was it introduced in the Philippine legal system? How does it serve as a protective remedy to uphold an individual's right to life, liberty, and security, especially in cases of threats, enforced disappearances, or extrajudicial killings? Hi, I'm Attorney Mike Navallo, Supreme Court Chief Communications Officer. It's the 19th of September 2025, and today we talk about one of the protective legal remedies, the Writ of Amparo. We will try to learn more about this protective remedy by citing Supreme Court decisions that granted the issuance of the Writ of Amparo during the discussion. And joining us to discuss this today is Dean Tranquil Gervacio S. Salvador III, Dean of the School of Law and Jurisprudence of the Manila Adventist College and Professorial Lecturer of the Philippine Judicial Academy. Hi, Dean Tranquil. Welcome to the Supreme Court Podcast.
Thank you, Attorney Mike.
Thank you for joining us, Dean, and for coming here to the Supreme Court. Dean, I came across an interesting fact that one of the questions in the 1991 bar examinations actually asked for the intent and constitutional basis of the Writ of Amparo. And if I'm not mistaken, you were part of that batch of examinees. So before we talk about the Writ of Amparo, allow me to ask you, could you share with us your experience during the bar exams in 1991?
I'll be happy to share that with you. If you would recall, at the time, the bar exams was a bit different.
Yes.
First, it was manual, and aside from that, there was no distributed syllabus as it is today.
Oh.
When we review for the bar exams, what we actually do is that just to cover everything.
Mm-hmm.
Everything that we have studied, everything, every rule, every procedure, including jurisprudence.
Mm-hmm.
So having that in mind, we prepared for the bar exams. On the first Sunday of the bar exams, which is political law, and at this point, you would note that barristers or examinees are a bit jittery. They're a bit nervous. That's the first Sunday of the bar exams. It's political law. When the questions were distributed, of course, we started reading. I saw some people not moving. Some were a bit shocked. So when I saw the question, I read it.
Mm-hmm.
It pertained to Writ of Amparo. So I paused a little. I said, I am quite aware of the various writs in the Philippines, but this is not a Philippine writ. So I cannot figure out the answer at that point. So remembering what my father told me, if you don't know the answer for a given question, skip it for the time being. Don't be rattled. Don't be affected. And considering that's the first Sunday, that's the first question of the first examination of the bar exams. So what I did was to look at question number 2 and then question number, I could answer this.
Oh.
So I proceeded to answer every question. I was successful in answering every question. And then going back to the first number, which I have no answer at that point in time, I still remember what I did.
What
And
did you
allow
do?
me to share this with you. I prayed. That's true. I prayed. I said, please guide me as how to answer this. I'm not sure how to answer this, but I gave my all. I will not leave a blank. I think I answered it close to a writ on property with other rights, and then I submitted my paper.
And you passed.
And I passed, and I was successful in terms of the bar examination. So I would say that it was quite a surprise for a lot of examinees. And please take note that some of those examinees did not return the second Sunday. Some did not return, and some were affected in terms of the outcome. And I recall the percentage of passing at the time was only 17%.
Wow.
One of the lowest in the bar examination history. We were just around 400 plus, almost 500, who took the oath from around 2,000 plus examinees.
So that was a killer question, Dean.
I would say, that's why I always tell my students, if I may say this, I always tell them, if you're confronted with a difficult question, pause. Think about it. If you don't know the answer to the question, move on to the next. Don't be affected. Don't get rattled. Remember, at that time, we were still using fountain pens. Fountain pens, not the ordinary pen. So it's manual, it's fountain pen. And of course, sometimes some of them stop. And the small things that will be reminded of you, like put your ink on your right instead of the left, because when you move you might hit your ink, it might spill and will affect you, your composure. Little things. There are a lot of little things that you have to watch out for before.
Very interesting that you mentioned this thing, because this was 1991.
1991.
And the Writ of Amparo was not passed until 2007.
You're correct, Atty. Mike. It was only in 2007. And I am not too accurate about it, but after that, it was asked thereafter several times. Yes, you could check that out. And it's only in 2007 when it was promulgated by the Supreme Court. And I think our listeners would have to know that this was based on the rule-making power of our Philippine Supreme Court as provided for under the Constitution. Article 8, Section 5. And if we will read carefully that provision of the Constitution, you will see that the Supreme Court was given the power to promulgate rules concerning protection and enforcement of constitutional rights, pleadings, practice, and so on. Yes, Attorney Mike.
And Dean, many people could be looking at the Constitution, could not find the actual words Writ of Amparo there, right?
Right.
But there's a way to actually interpret the Constitution so that the Supreme Court can come out with rules, such as the Writ of Amparo.
Yes. First is the power to promulgate rules provided for in Article 8, Section 5, subsection 5, that gives them the power to promulgate rules for the protection and enforcement of constitutional rights. So that's one. We also have to take note that under Article 3 of the Constitution, the Bill of Rights, there is that due process clause.
Yes.
The right to life, the right to life. And the right to life covers with it not only to be alive. The right to life extends to the quality of life that we will live. Freedom from fear, that we are secured. And there is another section in the Bill of Rights that we have to be secured in our homes, in our residences, in the privacy of our homes, from unreasonable searches and seizure. So these rights must be protected. And if you look at all of these rights embedded and scattered around the Constitution, then you will see the reasoning behind the Writ of Amparo. And that gave birth to the Writ of Amparo.
How did this come about, Dean? What's the history behind this?
Okay, that's a very nice question, Attorney Mike, and I'm very excited to share about the history of the Writ of Amparo. This was formulated by Mexico, Mexico, that spread over other Latin American countries in the Western Hemisphere. And the concept of Writ of Amparo then was broader. Okay, it's really broad. So if you look at it, allow me to share with you how broad it is, how broad it is. In their jurisdiction, Mexico and the Western Hemisphere, it was broader than our concept of Writ of Amparo. First, for the protection of personal freedom, it is equivalent to our habeas corpus. Right.
Freedom against illegal detention.
Or amparo libertad. Okay. Number 2, for the judicial review of the constitutionality of statutes, which we could do.
Yes.
That's the power of our Supreme Court, provided also in Article 8. It's called amparo contra leyes. So you would see it's really scattered. You have writ of habeas corpus. You have the power to review constitutionality of laws, amparo contra leyes. And number 3, for the judicial review of constitutionality and legality of judicial decision, which is the power of the court to review decisions of courts. It's also provided for in Article 8. It is what you call amparo casación. Okay? And then we have also, number 4, for the judicial review of administrative actions, which is also included in Article 8, Section 1, the power of the Supreme Court to what? To review actual controversies. Okay? Actual controversies if there is grave abuse of discretion amounting to lack or excessive jurisdiction. And we call it sometimes judicial reach. That was given under the 1987 Constitution, and we call it amparo administrativo. So hindi lamang, not only that of administrative agencies, but also acts of the judiciary or any branch of the government for that matter. Then, number 5, for the protection of peasants' rights. That was part of the original Writ of Amparo in Mexico, derived from agrarian reform process. And that's respected also under our Constitution.
Right.
And there are separate domestic laws on the matter. And we call it, and they call it, amparo agrario. Okay?
It's far-reaching, it's wide-ranging, but in our case, Dean, the writ of amparo may be limited to certain cases, right?
And it's good that you mentioned that, because in the Philippine experience, it's violation of life, liberty, and security.
Right.
Although, kindly take note, the beauty of the Philippine Writ of Amparo, it extends to threatened acts, not only actual violations. Threat of violation is included. And you see how the foresight of those who drafted it, that it is really to protect constitutional rights of a person being secured in his home, in his privacy. You see, that's what they intended to achieve. That's the beauty of it. And for the first time, it was made very, very clear that the writ of amparo, kindly take note, extends to situations wherein it's a violation of a public officer or an employee. And it extends to those private individuals or entities who may violate right to life, liberty, and security.
Right. And Dean, you mentioned that this came from Mexico. It was adopted here in the Philippines. I believe there was a summit in 2007 that led to the crafting of this writ. But many might be asking, if we already have the writ of habeas corpus in the Constitution, why is there a need for writ of amparo?
A very good question. You know, the writ of habeas corpus has been there. The writ of habeas corpus addresses unlawful confinement and detention. So it's directed against an institution or the government that is believed to be holding an individual, okay? Unlawfully detained individual. But the thing is, it does not specify who the violators are. So the impact of writ of amparo is far broader. And it also tells us there that unlike a writ of amparo, unlike a writ of habeas corpus, which could be filed by anyone, a writ of amparo, there is a structure on who could file. Ideally, it's only the aggrieved party who could file to the exclusion of the rest. But if the aggrieved party, for example, is detained, he or she is missing, then the immediate members of the family could file.
Unless if there's no known immediate members of the family.
So first, that's the spouse, the children, or if there are none, collateral relatives within the fourth degree of affinity or consanguinity. Now, however, there are instances, as you mentioned, that there are no known relatives. Only then will other concerned institutions, associations can kick in. So there is an order.
And Dean, let's also distinguish this from another writ, the writ of habeas data.
Okay.
How are they different? I know we will discuss this in the next podcast, but just very briefly for our listeners who might be wondering right now.
The writ of habeas data or data, some may call it, this is really protection to the right of informational privacy, as they say. So, the intention is to protect us from collection of what? in connection with violation of life, liberty, and security, gathering, collection, or storage of information in connection with our names, our background, our homes, and that would have an impact on our integrity and our honor as a person. So generally, that's why the writ of habeas data or data is directed more on privacy, if you would know.
Privacy.
Yes.
Yeah. Let's talk about what the Writ of Amparo covers in the cases. Because I noticed that in 2007, just before the passage of the Writ of Amparo, there were a lot of cases of enforced disappearances, extrajudicial killings.
Correct.
And so people were clamoring for a remedy to address this, which could not be covered by Writ of Habeas Corpus, right? So how does this address cases of enforced disappearances and extrajudicial killings?
It's good that you mentioned that, because in most jurisprudence, there is such a statement. Enforced disappearances, extrajudicial killings, which is really what, among others, the Writ of Amparo would like to cover. Now, if you look at this, the good thing about the Writ of Amparo is that it provides for you a specific remedy or process to immediately find, for example, a missing individual or someone believed to have been killed extrajudicially. So there is a specific process. Unlike in habeas corpus, although there is that provision in Rule 102, if I'm not mistaken, 102 or 103 of our special proceedings, here it's broad. It tells you where to file it immediately. Let me walk you through. You could file it in the RTC where the unlawful act or omission was committed by the public official or a private entity. You could file it in the RTC, the Court of Appeals, and the Supreme Court. They have concurrent jurisdiction. And it could be enforced once granted in the entire Philippines. Now, if you would note, when this gets to be filed, there is no requirement of filing fee. Walang docket fee ito. There is no docket fee. Because of the nature of the writ, there is no docket fee. And the thing is, you could file it at any time of the day. Probably because of the urgency.
Yes.
Okay, the urgency, you could file it any time of the day. And then if it gets to be assigned to a judge, you would note that he has to act based on the wording of Section 6 of that administrative matter issued by the Supreme Court. The judge or the justice will have to act immediately. Okay, not several days, but they have to act immediately. And if he finds that there is what? That there is basis for the issuance of the Writ of Amparo, he has to immediately issue. Okay? An order upon his seal. In fact, the beauty of this rule is that if, let's say, it's holiday, it's weekend, and the judge, upon examination of the record, finds that there is really basis for Writ of Amparo, upon his hand, he could issue a Writ of Amparo.
So this is ex parte?
Yes.
And immediate?
Yes, immediate. If he sees it in the petition itself.
Let me just clarify a bit about the procedure, Dean, because if you file before the RTC and the CA, you could issue, perhaps the judge or the justice can issue the Writ of Amparo and conduct hearings. But if you file it in the Supreme Court can issue a Writ of Amparo, but it will direct the Court of Appeals to conduct hearings. Why is that?
It's returnable. Okay, it's returnable. For the Supreme Court, they will require the return or the equivalent of the answer to be filed with the Court of Appeals. The reason being that, of course, as we know, the Supreme Court is primarily a court that reviews questions of law.
Yes.
While it is within its power to examine facts, conflicting facts, complex facts, but it primarily reviews questions of law. So that's why, if you would note, if I could expand that discussion,
please go ahead.
The Supreme Court will require the Court of Appeals
to conduct hearings.
To conduct the hearing and to receive the return. Or if the writ it is filed in the Court of Appeals, the Court of Appeals can require the return to be filed before it, or could require it to be filed before the RTC. Okay? Or if the RTC issues it, the RTC will require the return to be filed with it. So there are possibilities on where the return is to be filed.
And then you mentioned earlier who can file. And right, it's possible to also file on behalf of another person, right? What are the requirements for this, for one to be able to file?
For one to be able to file, and I think you're referring to someone who is not a relative.
Yes.
Is not a relative. What is important here, if you look at the provision of the rule, it doesn't give you a very extraordinary standard. It only says that a concerned association
Yes.
or organization. So a reasonable judgment of those organization, concerned organization or association, based on the facts as presented to them, may trigger the filing of a petition for writ of amparo. And that leads me to my next statement. Facts are very important
Yes.
because sometimes people come to court with conclusions, with suppositions, with conjectures, just making imputations. And that is why, not only in the cases of writ of amparo, they will be surprised why a court will act in a certain manner when they have already concluded upon themselves that this should be the action of the court. Right? It's very important that when you come to court, and this is consistent with Rule 7 of the Rules of Court, that if you lay a claim, a pleading lays a claim or a defense, Rule 7, Section 6, you should have judicial affidavits based on your personal knowledge of the
Yes.
affiants. You just don't come to court and making imputations, allegations. And of course, if there are evidence, you also have to attach the evidence, documentary evidence, and object evidence.
So you cannot just merely invoke that there's a threat against you.
Yes.
You have to be able to prove it.
Yeah. And if in my years of reading cases, that's sometimes the problem. Because they think that by making allegations, imputations based on a particular rule, the Supreme Court or any court for that matter must be forced to act. No. They will have to wait out. They will have to read it. They have to understand, is this really with sufficient factual basis?
And you said also that this isn't just applicable to government officials. You can file a petition for writ of amparo against private individuals. What are the situations when that might happen,
Well,
Dean?
it's possible that the one possibility is that the private individual or a private entity may be in cahoots with a government employee. Or a private, or another scenario would be that private entity or individual is really violating the life, liberty, or security of another person. Not necessarily in connection with any governmental act. So this is, you would see how broad it is.
It is broad.
Right? The thinking then was, it would only be probably government employees, officials who would restrict or detain you.
And supposedly this would cover vigilante groups
Yes.
acting on their own.
Yes.
Right?
Yes. So it's you would note that the original intent would have been to cover all possibilities, all respondents who violates the life, liberty, and security of another, or threaten to violate the life, liberty, and security of another.
And to underscore the urgency of this, Dean, are there time periods within
Oh,
which
yes.
the court should act?
Yes. So as I mentioned, so once they receive it, whether the justice or the judge, they will have to act on it immediately. Now, if, for example, they issue an order and they require the filing of a return, a summary hearing could be conducted within a period of 7 days from receipt of the order. Okay? And that the hearing, okay, according to Section 13 of that administrative matter, should be conducted day to day until it is completed. And if you would note, from the time it is submitted for decision, the court, the judge or the justice will have to resolve it in a period of 10 days. Ordinary, once it's submitted for decision. In an ordinary case, it's 90 days from the time it's submitted for decision, right? And then if you disagree with the findings of a court, for that matter, in a petition for writ of amparo, you have 5 days to elevate it to the Supreme Court on a Rule 45, on a petition for review and certiorari.
So the periods are really intended
Yes.
so that action could be done immediately
Yes.
in these cases.
And there's a mention in the circular or in that administrative matter issued by the Supreme Court that they should be treated with the same urgency as a petition for habeas corpus. Yun.
And what would be the outcome, Dean? Are there going to be instructions to law enforcers to do this or to do that?
That would depend on the findings of the court. And later on, I think we may, I could discuss with you, just like the case of Jonas Burgos.
Yes.
This is a highly publicized case. This was resolved by the court sometime in 2010, if I'm not mistaken.
Yes, 2010.
And the supposed abduction in Commonwealth, in a restaurant in Commonwealth, took place in 2007. So this was a time that you would know that the original action actually was habeas corpus. Because they were not yet familiar with writ of amparo. Although the mother was the one who filed. There were others who filed petition for habeas corpus, but the mother, Edita, filed for a writ of amparo. But if you would note, the finding of the Supreme Court here was, again, factual matters. You would note factual matters. The Supreme Court said the law enforcement agencies should have conducted the proper investigation. And that the Supreme Court will not be in a position to ascertain the facts. So what the Supreme Court did in that case of Burgos is to refer the matter to the Commission on Human Rights, which was given by the Constitution the power to make sure that the rights of people are protected. And they were given 90 days to make a report. So if you would know, they were given 90 days to give a report. So here, there was really no resolution yet. The investigation was referred to an agency of government, the Commission on Human Rights.
Is that the ideal? Din in a writ of amparo?
It's a very good question, actually. Is it ideal? The ideal, of course, is that the writ should be issued. And that action should be immediately taken, because in situations like this, especially in extrajudicial killings, enforced disappearances, there's a possibility that it's just a matter of time. It's a question of life and death. So, again, but of course, we have to weigh that out also. Courts cannot issue orders or writs without factual basis. And that is where it is incumbent upon petitioners or those coming to court to make sure that everything is in order. While courts can conduct hearings, don't get me wrong. At that point in time when they filed the petition, probably the facts are a bit not so clear yet, right? And so they will have to sought refuge from the court. But again, in the course of the proceedings, they should be ready to present evidence.
Right. And Ding, at this point, let me just clarify also, because this has been a cause of confusion for many lawyers as well.
Yes.
The writ of amparo that's initially being issued by the court is different from the privilege of the writ of amparo, right?
Right.
So how do we distinguish that? And when the privilege of the writ of amparo is actually issued, what kind of obligation does it entail with respect to law enforcers?
Well, when the privilege of the writ of amparo is issued, they will have to comply. And when you have to comply, if you are in custody of these individuals, you have to present it to the court, to present the body. If you have knowledge of the same, of the whereabouts, probably you will say, I am not in custody of these people. You are what? Maybe a responsible officer. Because the concept of a writ of amparo is that it is not a criminal case that determines liability. It's not a civil case. It's not an administrative case. It is a remedial measure. That's why it has to be urgent. And that's why when the writ of amparo, the privilege, is released, they will have to comply, because this is a remedial measure. They identify there who is responsible, the actors who participated in the violation. It will be indicated in the privilege. And it will also not only indicate who violated, but it may also indicate who are responsible in terms of command responsibility. Do you have knowledge? Did you discharge extraordinary diligence in making sure that an investigation would have taken place? Or that having heard the report or submitted the report to you, you should have acted accordingly.
And this idea of being able to identify who are the perpetrators may be difficult in some instances, especially if you don't have witnesses. But in this one case that we will talk about, the case of Shirley Cadapan and Karen Empeño, there was actually a witness who claimed that he saw them in a military camp. So how crucial was that in their petition for amparo filed by their mothers?
That was very critical. That was critical because if you would note, that was the basis of the appellate court, the Court of Appeals, in ordering the release. If you would note, let us give them a bit of a background. When it was filed, the petition was again for habeas corpus. For habeas corpus, and that was dismissed. That was actually dismissed. So it was only granted on a motion for reconsideration after presentation of these facts, revisiting all of these facts, wherein they said, well, you release those respondents, military officers, you release, they said. But while the motion for reconsideration, that was the grant, and while that motion for reconsideration was pending, it was then at the time that the mother filed an amparo. That's why when it reached the Supreme Court, it was already a consolidated petition in the Supreme Court, both questioning the habeas corpus and amparo. One decision made by the court.
And this idea of command responsibility, Dean, how important is it that it was applied here in a writ of amparo case.
Yes, because as explained by Father Bernas, command responsibility is your obligation to oversee and to make sure that your subordinates are acting within the bounds of law. And of course, it is also a manner of determining whether or not who are those individuals who are complicit in causing the abduction, on why the person is missing. And more importantly, the command responsibility here was discussed not to point out who is criminally liable, but to determine who is responsible and accountable. And as I mentioned a while ago, when you talk of responsibility, who are the actors? Who played the role in those actions, in those violations? And when you talk of accountability, who should have knowledge, who should have discharged the proper duties in order to avoid it, to conduct investigation, so forth and so on.
So if you are not able to identify who the perpetrators are, but you're able to pinpoint who the leaders are, who are responsible for, say, for that particular military camp, for example, then you have this remedy that can still apply.
Yes,
Right.
because they are responsible officers. It is believed that probably they are in a particular camp or in a particular location. So, the writ of amparo can play a role.
And there's another recent case on this, Dean. If I may just quote from Tabian versus Gonzalez. This was penned by Associate Justice Josep Y. Lopez. It was decided on August 1, 2022. And for those listening, you may check it out. GR number 247211. If I may read a quote here, Dean. The writ of amparo is a protective remedy aimed at providing judicial relief consisting of the appropriate remedial measures and directives that may be crafted by the court in order to address specific violations or threats of violation of the constitutional rights to life, liberty, or security. So in this case, Joselito was shot dead by police officers during an alleged buy-bust operation. But instead of filing a criminal case for the killing, the wife of Joselito filed a petition for issuance of a writ of amparo. Why do you think that was the chosen remedy?
I think she was unclear as who committed the offense.
I see.
Because the husband was killed, right, in a buy-bust operation. If you're able to read it in the original, it may appear that they're even friends of the policemen who actually caused the extrajudicial killing. Okay, and then so what happened was she was uncertain, and here the Supreme Court, and she filed the petition for writ of amparo, and the Supreme Court explained again who is responsible and who is accountable, and more important than that, by knowing who is responsible and who is accountable, then these are preliminary measures to be taken in preparation to the filing of the appropriate criminal action.
So this could be a preliminary step.
To the filing of the criminal action. If, for example, by using the petition for writ of amparo, you're able to identify who actually violated the life, liberty, and security of a person, then, and in the course of the hearings, of summary hearing of the petition for writ of amparo, evidence are made evident that indeed these people may have committed the crime, then you file a criminal case.
And what's interesting here, Dean, is that even the threats to the life of respondent was recognized by the Supreme Court.
Yes. And this is unique in a sense because you would think of it as just a crime. It's not really just like probably politically motivated and all of this. But this is a crime. But it's something that the Supreme Court recognized that everyone, for that matter, should be secured in their homes.
Yes.
Because it was Joselito, the husband, was taken when he was at his home.
And let me just quote again one finding here, which I find interesting. The failure of the petitioners to duly investigate is a violation of the respondent's right to liberty and security.
Yes.
How significant is this pronouncement?
Well, the duty of this respondents was clearly to investigate. Their duty is to see to it that probably all people within their jurisdiction are safe. And therefore, failing to do so, that exposes them to liability. And they may have committed not only a criminal act, they may have committed an administrative infraction by not complying with the duty to protect the life, liberty, and security of the person.
And then you mentioned earlier that this could be, the filing of a petition for amparo could be a preparatory step for the filing of other cases. So in short, it does not bar the filing of civil, criminal, and administrative cases against law
Yes,
officers.
Attorney Mike, it does not bar. So you file a petition for writ of amparo, you later file a petition for a criminal case, you could proceed. You file later a civil case, you could, or an administrative case.
And I'm curious about the findings of the court. For example, if one court issues a writ of amparo with the findings that these are the officials either responsible or accountable for the killing or perhaps the disappearance of this person, can that be used by another court trying the criminal, say, civil or other cases?
Actually, that's a good question. That's a very good question. You know why? Because general rule 129, judicial notice.
Yes.
The court cannot just take judicial notice of matters taken up in a pending case.
Okay.
Unless it's a published decision of the court. Right? You cannot just take judicial notice. It only happened in one case wherein there is a civil case and a criminal case raffled before the same judge. Even that situation, the court cannot take judicial notice unless the other party or the parties are informed of that fact and there were no objections. So in that case, my answer would be, generally the court cannot take judicial notice of matters pending or deliberated in other courts or tribunal. However, they could present the witnesses. They could present the documents, and probably they could include in their pleadings or submissions the initial action of a particular court so that the court is aware. You bring them to the attention of the court. You do not expect the court to know.
Yes.
Right? Because it's the process is ongoing.
Right. So that's a strategy for at least for the prosecution
Yes.
at least. Now, Dean, it's been almost 20 years since
Yes.
the issuance of the writ of amparo. How would you assess its effectivity? How effective has it been in addressing enforced disappearances, for example, or extrajudicial killings? And what challenges are you seeing in terms of its enforcement?
Personally, I think it is an effective procedural tool or measure, except that there are challenges in terms of realities that we see. Of course, if you file a case, as I go back to my statement, there must be clear facts, ultimate facts supported by evidence, and you have witnesses. As was seen in the case of Boac, right? Sherilyn and Karen and Manuel Merino, their immediate release was brought about by the testimony of witnesses.
Yes.
So I think the challenge really is to be able to immediately get evidence. Because, the families are sometimes rushing, worried, panicking. And that would not be the first order of the day.
Yes.
Your first concern is, let's look for them, where they may be. Let's go to this place. Let's go to this camp. Let's go to this private real property just to look for our relatives, right? So that is their priority. But that's why I would suggest for the lawyers who are assisting them, look into this matter and make sure that the facts and the evidence are in order so that the courts will not have difficulty.
And how relevant is the writ of amparo today, Dean? Given the human rights challenges that we're facing, is the writ of amparo still relevant?
Very much relevant and will be relevant in the coming days. But what we have to remember is how to further improve this in light of possible other circular to be issued by the Supreme Court. Why? We are now in this information age.
Yes.
Because your threat to security or violation of your security is no longer probably as we see it. Crimes
No
could
longer
be,
just physical.
It's no longer physical. It could be digital. It could be online. It could be electronic. So this is something that the courts may consider in the coming years to come. Because the life is changing.
Yes.
Life is changing, and after the pandemic, if you would note, it's completely a different world.
Yes, it is. Even the processes of the court are evolving.
Yeah, if you would note,
Yes.
even the filings are
The filings are electronic now, and we are actually in the process of revising the rules of court.
Exactly.
So it may just be a matter of time before we revisit the writ of amparo and the other extraordinary writs.
That's
Now,
right, Attorney Mike.
Just to close our discussion today, Dean, what should be our key takeaway, at least for citizens, lawyers, future lawyers, regarding the importance of understanding and asserting this right?
The key takeaway that I could share with you would be, you should know your rights. And by knowing your rights, you should be able to avail of it and be ready to have it enforced. Because you cannot just sit back because I'm not generally affected. Because at some point, if we just ignore the things happening to us, we may be affected at some future time. So my suggestion is what? Make sure that you know your rights, apply for it, and make sure that it is enforced so that our entire community will benefit from it.
All right. Thank you very much, Dean Tranquil. This has been a very engaging discussion.
Oh, yes. Thank you,
And
Atty. Mike.
We hope to have you back again for the next episode.
Yes.
Thank you so much.
Thank you for this time.
All right. And if you wish to read the full text of the rule on the Writ of Amparo, please visit the Supreme Court website. Here's Tiff Atendido Beltran, Supreme Court Information Officer, for this week's updates.
From the Supreme Court of the Philippines, here's the latest. A total of 11,425 applicants completed the 2025 bar examinations on Sunday, September 14, 2025, the highest number of finishers in Philippine bar history. 11,437 examinees turned out on the first day of this year's bar exams, which continues to be digitalized and regionalized, held in 14 local testing centers across the country. On the same day, 2025 Bar Examinations Chairperson, Associate Justice Amy Lazaro Javier, officially handed over the responsibility of administering the bar exams to Associate Justice Samuel Garlan, who will serve as chairperson for the next bar. Meanwhile, the SC Bank, during its special session on September 15, issued a temporary restraining order, or TRO, preventing the Commission on Elections, or COMELEC, the Bangsamoro Transition Authority, or BTA, and all persons acting under their authority from implementing the Bangsamoro Parliamentary Redistricting Act of 2025, or BAA 77, pending the final resolution of these cases. Two sets of petitioners questioned the measure which redistributes the districts left behind by Sulu when the Supreme Court declared the island province not part of the BARM. The first set of petitioners challenged BAA 77 for allegedly violating the Voters Registration Act by altering precincts during the election period, while the second set of petitioners argued that BAA 77 is unconstitutional for violating the provisions on ensuring free, orderly, honest, peaceful, and credible elections during election period. The SC ordered the COMELEC and BTA to file their comment to the petitions within 5 days. In another ruling, the Supreme Court has recognized the group led by Alfonso Cusi and Melvin Matibag in resolving the leadership dispute in Partido Demokratiko Pilipino Lakas ng Bayan, or PDP Laban. In a decision written by Associate Justice Jopar de Maampao, the SC Bank dismissed the petition filed by former Senators Aquilino Coco Pimentel III and Emmanuel Manny Pacquiao, which questioned the Commission on Elections, or COMELEC's recognition of the Cusi-led group. Upholding the COMELEC ruling, the SC clarified that under PDP Laban's constitution, the vice chairperson may take over the chairperson's duties in cases of absence or incapacity. Here, the chair, the former President Rodrigo Duterte, had already authorized Cusi as vice chairperson to organize and lead the May 31 meeting through a memorandum dated May 17, 2021. Despite the procedural issues, the SC ruled that the meeting was valid because a proper quorum was present. Because the May 31 meeting was valid, the actions taken during and after it, including the July 17 National Assembly, were also valid. On Thursday, Senior Associate Justice Marvic M.V.F. Leonin reminded judges to always act in the best interest of the Filipino people in the performance of their duties as public servants, as he stressed that corruption has no place in the judiciary. Speaking at the Metropolitan and City Judges Association of the Philippines 25th Annual Convention and Seminar in Taguig City, Saj Leonin emphasized that corruption weakens the rule of law and erodes public trust in government. He also discussed the court's efforts in transforming the courts to make them more efficient and responsive to the needs of our people, citing initiatives under the Strategic Plan for Judicial Innovations 2022 to 2027. SC Associate Justices Rodil Zalameda, Amy Lazaro Javier, and Henry John Paul Inting, and officials of the Office of the Court Administrator also served as speakers. Themed The Judiciary and Beyond, the 5 Pillars of Justice and the SBJI, the convention also tackled digitalization, technology and cybercrime, access to justice, and AI within the context of courtroom evidence. The Unified Legal Aid Service, or ULAS Interim Board, has granted a 1-year continuing accreditation to 3 institutions whose regular and recurring legal outreach programs and legal missions are recognized as eligible for ULAS accreditation. These institutions are the Integrated Bar of the Philippines, the Department of Justice Action Center, and Law School Legal Aid Clinics. In an advisory released on Monday, September 15, SC Associate Justice Alfreda Benjamin Caguiwa, chairperson of the Unified Legal Aid Service, or ULAS Interim Board, set the guidelines for the 1-year continuing accreditation. Covered lawyers who provided pro bono legal services through these institutions will be credited with the number of hours rendered. Finally, on September 15, the Judiciary's basketball team, the Judiciary Magis, headed by Associate Justice Jose Midas Marquez, conducted an outreach activity for Children in Conflict with the Law, or CICLs, in Tanay, Rizal. The Magis took part in an exhibition game during a sports fest organized by the Department of Social Welfare and Development's National Training School for the Boys, which provides protection and care to CICLs. After the games, the Magis turned over the donations, which included apparel, sports equipment, and food. You are now up to date with the Philippine Supreme Court. I am Tiffany Dobletran, Supreme Court Information Officer.
And that's our podcast this week. Join us again next time for a detailed discussion of select cases decided by the Supreme Court. I'm Attorney Mike Navallo, your Supreme Court Chief Communications Officer. You can catch this podcast on the Supreme Court Public Information Office's accounts on X, Facebook, Instagram, Threads, YouTube, and Spotify. You can also catch previous editions on our website and on Spotify. This podcast episode was produced by the Supreme Court Public Information Office with Attorney Karen Martinez, J. Rempilio, and May Sibal as researchers, Brian Ostrea, Don Ryan Balza, Victor Laranio, Lawrence Olanio, Austin Aliscad, and Bea Batung as audio and video editors, and Taik Flores and Jerome Batumalake as web editors.